Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, and I, of course, have the wrong screen up next to me. So, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. If you're ever in Minnesota and run into any legal issues, please look me up. We'll see if we can help out. So here's the thing, guys. Yesterday night, morning to the earlier today, whatever you want to look at it as, I published an interview or posted an interview with a guy named Diversity in Comics, who is a fellow YouTube creator, and you should definitely check out that interview for a full discussion of this topic and the backstory and the history of what's been going on. Today, I'm coming to you with a shorter video that is a summary of the legal issues, because it's like an hour and a half interview, and I want to be able to bring the legal issues, because that's what this channel is fully about, right? Bring the legal issues to a shorter video that's a little more in depth about the law, but also getting rid of a lot of the exposition and backstory, so that you guys have a quick source on what legal issues we're looking at. The way I see it, from the facts that I have, we have like three distinct kind of legal issues. One is defamation from people like Mark Wade, and I'm going to focus on Mark Wade specifically because some of his comments appear to be defamatory based on the information that I have, and we'll talk about that, okay? The next thing that I have is tortious interference with a business relationship or with an expected business contract. There are a lot of different ways to talk about tortious interference. We're going to look at what the court actually says the elements of tortious interference are, and talk about what needs to happen for this to actually be tortious interference under the law. And then the final one is this weird sort of collusion issue going on behind the scenes that unfortunately I don't have a lot of documentation about, but might amount to, and it depends on what's out there, it might amount to some unfair practices in violation of the Sherman Antitrust Act, which is a really, really, really old law that is still used and defines how businesses interact with other businesses in a competitive market. And not just how the businesses interact with their competitors, but how distributors, suppliers, retailers, wholesalers, how all of those businesses interact to maintain a competitive market. Because long ago, Congress decided that competition amongst companies was the best way in a free market for consumers to get what they wanted at the lowest prices, right? Competition drives down costs, drives up jobs, drives up commerce, all of those things. So the Sherman Antitrust Act has been on the books since 1890. It has had some changes over the years, and we're not going to do a history of it because that'll take way too long. But just know that it's still in effect, and we still use it, and there are lots of decisions on it. Thousands of controlling decisions on it. And so no, this is not a comprehensive review of what is legal and illegal under the Sherman Antitrust Act, but we're going to talk about whether some of these things might rise to that level. So let's get started first with defamatory statements by Mark Wade. Now, I don't have all of them, and Mark Wade has deleted his social media accounts, allegedly. He has pulled back, this stuff is kind of, you can only find it in screenshots from other people. But here is the scene next to me is a good indication of what is kind of going on, to give you a little bit of a preview. So we have the Antarctic Press saying that they're publishing Jawbreakers in September. It'll be different than the graphic novel ordered on Indiegogo. We'll have a different cover. That was published on May 9th at 11:14 p.m. Mark Wade then makes a statement that he has a call into the Atlantic Press, which I'm going to read in just a second. And then after that, and I don't have the dates on these because, again, these are screenshots that were taken, pretty close to around this stuff. But so the way it looks on the screen, though, is the top left, then the right, then the bottom left. That's the chronology of this particular chain of events. So Mark Wade says, I have a call into Atlantic Press. Until I hear back, I'm hesitantly willing to give them the benefit of the doubt that they don't really understand who or what they're getting into business with, which, though it would seem a stretch, is a possibility. If I do hear back, I'll report in. Curious as to how they feel about publishing creators whose marketing strategy is to allegedly encourage their fans to threaten the employees of stores and or harass and one-star review bomb stores that don't order their product. Are we as creators responsible for the actions of our fans? Ultimately, of course not. But it is morally bankrupt for creators with a voice to pretend they have zero influence over their fans, and it is incumbent upon them as human beings in a society to use that influence to intervene if and when people are getting harassed or threatened in their name. You can bet your butt that if I ever found out that any of my fans were spreading misogyny, transphobia, racism, or bigotry as a way of supporting my work, I would take active steps to shut that stuff down in a cocaine heartbeat, not just shrug my shoulders. And a little bit of editorialism, maybe that is why Mark's sales are tanking, because he is telling his fans that they're horrible people. But, I don't know. I don't know if that's the problem. But here's where the problem comes in, okay? We have allegedly encouraged their fans to threaten the employees of stores and or harass and one-star review bomb stores that don't order their product. Now, the problem with all of this is I don't have all of the stuff Mark Waid has said about diversity in comics. And I don't have everything diversity in comics has said either, because some of that stuff seems to be missing as well. Of notoriety, something we're going to look at a little bit later, is there was apparently a series of tweets with screenshots from a closed Facebook group of retailers. We're going to talk about them in a little bit, and I only have kind of a redacted version of the first one because that Twitter chain doesn't seem to exist anymore. If it's out there and I can't find it, I apologize for being inept, but I did look for it. It kind of looks like it got deleted. So I'm not saying that Mark Waid's the only guy deleting stuff. It looks like Diversity in Comics has deleted stuff here too. And deleting stuff on Twitter makes things harder to find, but ultimately, it's probably not actually deleted and may be discoverable still. Anyway, that said, the stuff I have seen from Diversity in Comics does not at all encourage their fans to do anything to employees of stores or harass or one-star review bomb stores. In fact, what it says is, do not call or harass people. Don't contact them at all. That's the tweets I have seen from Diversity in Comics. So if you've seen something else, please send me that information. I would love to be correct on this. I don't want to go out there. But let's assume that what I've seen is a relative expression of the truth. And on my interview, Zach from Diversity in Comics has said that he never encouraged anyone to do this. Not once. So if we accept that as true, then what Mark Waid is doing here toes the line of defamation. He has allegedly in there. He has a cough making the allegedly sarcastic. And I have heard there are other tweets of Waid flat out stating that this has happened. If that's true, that comes into defamatory territory because he's encouraging people to threaten and harass. That is probably not a crime because incitement is a weird sort of issue that we're not going to get into. But it is dishonest behavior, especially in an industry run on reputation. So if that's the case, these are defamatory statements. They're potentially actionable. I would lean towards them being actionable outside of Mark providing some better context in other tweets or things that he has apparently deleted and we may not have access to. And he may not have access to either. So that might make it a problem. So here we have another tweet from Mark. For those late to the circus today, put simply, a bunch of retailers in a private discussion talked about a comic book that they decided they didn't want to carry in their stores, as is their right in a free market system. We're going to talk about this in a little bit. I'm going to come back to this tweet. Remind me. Does your store carry every single comic book published every month? Everyone? Of course not. Stores choose what they think they can sell and what they're comfortable selling. In retribution, a campaign sprung up by which fans of this comic went on Twitter to identify these stores, disclose personal information about their employees, and encourage fans to call the stores and to harass them. threaten their employees and one-star review bomb them rather than accept the fact that no one is obligated to buy this book. And of course, the creators behind this comic are aware of all this and have taken absolutely no steps to intervene. That's not true, although I don't have the timeline or the chronology here, but Diversity in Comics did tweet out specifically, don't contact them. And I think I have, oh, here we go. Here's him quoting his original tweet. Mark Waid is a proven liar. He lied and said I encouraged harassment when I did the exact opposite. He implied I gave away private phone numbers when I only gave a couple of store phone numbers. Now, this is a crucial claim, too, because it shows what is a false statement. If Mark Waid has said that Diversity in Comics gave out personal numbers, which has been bandied about and I believe originated with Mark Waid, if he has made that statement, that becomes defamatory, because if those are not private numbers, if those are public store numbers that you can find like on Google, then that's not, then he hasn't done what Mark Waid has said he's done. So now he is hiding after the mess he made. He's referring to Mark Waid deleting his social media accounts. Here's the original tweet. Note, please do not contact any of the comic shop owners I am listing or harass them. Also, none of these people are ones that I promise not to identify their identity. That's an ugly sentence, buddy, but apparently, someone has leaked the conversation, and so I would wager that some of the people who were friendly to him in that conversation or friendly to his comic did not have their identities leaked, whatever that means. Oh, excuse me, or their phone numbers. But here's the whole thing. If you're publishing a list of stores and phone numbers because they're not going to carry your book for your fans, the fans can do what they want with that information, especially if it's public. But knowing that the comic store that they may go to isn't going to publish the book, they can then contact that comic store, not for the purposes of harassment or intimidation or anything like that, but to simply say, hey, I really wish you'd stock this book. Have you guys ever walked into a store, they didn't have what you wanted, and you'd said to an employee, hey, it'd be great if you carried this because I'd buy it. I'd buy it. This is a common thing. Calling up a store and saying, hey, would you please carry this because I'd like to purchase it? Or, hey, can I order this? I know you guys aren't going to carry it. Can I order it at your store? Do I have to go somewhere else? This is not a problematic thing to do. Absent some evidence that Diversity in Comics actually encouraged people to call and harass them, absent that, Mark Waid's tweets appear to be defamatory. So the elements of defamation, let's be clear about this, are an untrue statement said from one party to a third party, and that untrue statement causes injury to the victim. In this case, Mark Waid being the first party, the third party being anyone he makes a statement to. That can be in private, that can be on Twitter or Facebook, in public statements. It doesn't matter. He can honestly handwrite it on a note and hand it to a subway goer, and that's technically transmission as far as defamation is concerned. Okay, so if he and clearly he has made statements on Twitter and Facebook, and as we'll see, he has made statements to an online publication as well. So if he does that, so that's Mark Waid being the first party, third party being whoever he's talking to, and then the victim in this case being Diversity in Comics, making an untrue statement to a third party about another person that causes injury to that person, and injury has to be proven in a couple ways, or it can be presumed. Like if you say that someone's a murderer, that someone has murdered someone, you accuse them of a heinous crime in a real fashion, that's per se defamation. You don't have to prove damages, they're presumed. But in this case, they'd probably have to prove some sort of damage. And then and that's it, right? You make the statement, it has to be false, and then the statement causes damage, okay? That's defamation. Now, arguably, Diversity in Comics may be considered a public figure or a limited public figure. I highly doubt it. I highly doubt that, but it's possible. And in that case, you have an extra step, and that's called actual malice. Actual malice is that you know the statement is false. Now, I'm not going to get into the weeds on whether or not Mark Waid knew that the statements he was making were false, but there are some tweets out there where Mark Waid is challenged on them being personal phone numbers, for example, and him saying, well, I'm not going to look into it. Okay, well, that's a knowingly false statement in that case. You can't refuse to find the truth if it's discoverable, like, I don't know, an internet search. But you can't refuse to find the truth and then make the false statement and then claim, well, I didn't know it was false. It doesn't work that way. So you'd probably have actual malice in this case. It's quite possible that there is a defamation case here against Mark Waid based on the comments that he made about the retailer list. Okay. That's not even getting into what he may or may not have said to AP, Antarctic Press. But going back to Wade's statement, and sorry for bouncing around on this, but there's a lot going on here that could all be actionable in some sort of way. So keeping with the defamation track here, he has said something to Antarctic Press. We don't know exactly what it was. But Antarctic Press releases this statement. After careful consideration, it is the decision of Antarctic Press to not release the comic series Jawbreakers. Antarctic Press is a staunch believer in creators' rights and giving creators a chance to showcase their creation, allowing that creation to be judged on its merits. Kinda. Many forces, many of them should be viewed with great trepidation about how our society acts. We'll come back to that. Have led us to this decision. We do not take this decision lightly, as we do believe that there should be separation between art and the artist, and that separation has been blurred in our decision. We appreciate all our supporters and detractors in this process. Thank you for taking the time to read our statement. This statement will be removed in 7 days, which is a weird thing to put in your tweet, or in your Facebook post, but okay. So Antarctic Press is pulled back, and they are running massive damage control on some of these articles, and I'll let you guys go discover that. But here's the problem. We don't know what Mark Waid said to Antarctic Press, but if Mark Waid made a defamatory statement to Antarctic Press about diversity in comics, if anything he said in there was a lie, defamation, period, done. Injury is obvious because the injury is they pulled publishing of a book. Publishing and distribution have been pulled. They had some sort of relationship that was announced. It's official. There is a contract and agreement. We don't know the terms of it, but it doesn't matter. Then it's pulled. So either canceled or breach. We don't know. Doesn't matter for the purpose of defamation. Injury has occurred based on something, potentially based on something Mark Waid said. Now, to be fair to Antarctic Press and Mark Waid, they have denied that his statements were the sole cause of this or anything like that. That's cute. And denying that is great all day. But when you go into court and say, look, I had an agreement with these people, this dummy calls them and says lies about me, which we're going to talk about here, here, and here, and then they break up the contract, that's defamation. I don't care how much you idiots come out later and say that it's not, it wasn't this, it wasn't this, it wasn't this. It's what it looks like to a court and to a jury. And right now, it looks like defamation has occurred. Looks like. The defense to defamation is the truth. So there may be some information out here that proves it, either the statements Mark Waid said to Antarctic Press were entirely true. Every single statement was entirely true. Nothing was misrepresented. Then there's no defamation, and we have to move on from that. But that's how defamation works, guys. One party to another party making a false statement about someone else causes injury. If that someone else happens to be a public figure or a limited public figure, and guys, don't get public figure confused with not private like some dummies on Twitter. Public does not mean not private. A public figure has achieved pervasive notoriety. Diversity in Comics has about 65,000 followers, or 65,000 subscribers on YouTube. That's not pervasive notoriety. Not even close. We're talking The Rock, Beyonce, Tom Cruise, people who are identifiable to everybody. Not everybody, but like a ubiquitous, you can go anywhere and talk about Tom Cruise and you're probably going to find a bunch of people who know who he is. The other type of public figure out there is a government official in a matter relating to public concern. So, we're talking senators, governors, national congressmen, the president, high-level cabinet positions, Supreme Court justices. These are all public figures. As you go down the chain, the food chain to like state house, maybe they're a public figure, limited public figure in that state, stuff like that. Then as you get down to like city council, probably not. Okay. Unless they're speaking on a public issue, then they become public figures. But don't mistake what a public figure is, because it's really easy for people to misunderstand that. All right. And I am really, really wrong about this being a short video, but I want to make it thorough. So, okay. The next things are not going to take as long. Let's go to the Sherman Antitrust Act. Here it is real quick. This is section 1, and this is the general overview of what is an unlawful business practice. So this is section 1, trusts and etc. in restraint of trade illegal, and there's a penalty. So every contract combination in the form of a trust or otherwise. So that's a little confusing. Let me break that down. So because this is, written a long time ago, every contract, take the comma as an or combination in the form of a trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is declared to be illegal. That means that every agreement, change contract or combination to agreement, every agreement in the form of a trust or anything else in restraint of trade or commerce among the several states is declared to be illegal. That's what's important here. Okay. So every person who shall make any contract or engage in any combination or conspiracy hereby declared to be illegal shall be deemed guilty of a felony, and on conviction thereof shall be punished by a fine. So this is a criminal law. Now, this does not mean people are going to be prosecuted under it, but you can bring civil actions on the basis of criminal offenses, even if they're not convicted of the criminal offense. Think of O.J. Simpson was found not guilty of murdering Nicole Brown Simpson, was found guilty in a civil wrongful death suit based on the idea that she was killed by him. That's how civil has a lower standard of proof than criminal court, and that's a good thing. But that also means that these people may not be punishable in a criminal court for violations of the Sherman Antitrust Act, and they should not be. This is not like some grand criminal conspiracy, but they may rise to liability under this sort of theory of law. Okay, so what do we have here? We have here is the diversity in comics leak of the Facebook group. Okay. I'm not going to get into too much about this. This is redacted and this is only truncated because this is the only screenshot I can still find. So are any of the publishers here the ones putting out the diversity in comics book? One, I thought it was all Kickstarter, but if I'm wrong, I will 1000% drag any publisher interacting with them in a professional capacity. Respect. I count on doing the same. Drag and dunk as loudly as possible, and I'm real loud. Guys, this looks like anti-competitive acts of a group of retailers against a publisher and against a content creator. Now, you may think, oh, no, this is just someone, people have a right to not stock a book. They do. They absolutely do. You don't have any obligation to stock a product, sell a product, order a product, none of that. You have no obligation to do that. But you also can't enter into agreements, accords, conspiracies to not do it. Like once you get two people in a room agreeing to not do it, that's a violation of the Sherman Antitrust Act. That becomes an unlawful business practice. That's it. Like in all honesty, all of these, okay, the reason that you go out and you want to buy internet and you've only got one stupid internet company in your town that you hate and you know you can't get another guy, the only reason they're allowed to do that is because there aren't actually conversations that anyone can point to where Comcast and Cox Broadcasting got in the same room and said, you don't do this and I won't do that. Okay? It's just that the court has, maybe in a Pollyanna fashion, decided that these guys have never talked because no one can present evidence of the conversations. Okay? And that's the problem. Here you have evidence of a conversation of people looking to drag and dunk, dragging this publisher. This is unfair competition under the law. I'm sorry that a cavalcade of non-lawyers on the internet are definitively saying that anyone can just decide not to sell a product. Well, you can decide not to service someone, right? Like let's get an analogous legal comparison. I can decide who comes into my shop and who doesn't. Yeah, but if your decision always involves black people not coming into your shop, that's illegal. Even though you may have the right to refuse service to anyone, once you start refusing service to the same class of people, you go into unlawful territory. It's not much different on the Sherman Antitrust Act. Any number, like every retailer could independently come to a decision to not stock Jawbreaker's Lost Souls. But the moment you have a recorded conversation with several retailers agreeing that, no, we're not going to do it, we're not going to do it, we're not going to do it, and they're all in this little group, boom, antitrust problems. I'm not saying they will win on this issue, but it raises the legal question beyond one guy trying to not stock a book. Now it's a conspiracy, a contract, a trust in violation of the law. Every little comic book artist on Twitter talking about what you know about antitrust law, I'm sorry, but all of the opinions I've read are wrong. Okay, all of them. Maybe there's one out there I haven't read, but this is not complicated, and the body of law on this goes back 130 years. This is long held to be illegal practice. What they're doing right here, based on what else is in this conversation, may put nails in the coffin. DNC may have a claim here for antitrust violations. You may think, oh, I'm just a retailer, but here you are boasting about how loud your voice is and what you can do to publishers and distributors. Doesn't look good, guys. Doesn't look good. The question is, will the FTC take a comic complaint seriously? Maybe, maybe not. I don't know. This is publishing and it's big money. He's got $265,000 on Indiegogo for one book right now. If he could do that a couple times a year, he's $1 million business. So that's what Sherman Antitrust looks like. Legal activity, when it's individually concluded and individually done, even if it's a plurality of people out there individually coming to that conclusion, is just fine. The moment you get two people with influence in the same room, and I mean people who make orders are influential in this case, the moment you get two people in the room conspiring to do it, boom, it becomes illegal. A otherwise legal activity becomes illegal when you write down a conversation, you dummies. What are you thinking? Having this... Facebook isn't this magic thing. You literally should be in a dark room that no one knows about having this conversation if you're going to have it. Because once there's evidence, you've sunk yourself. Oh my goodness. Potentially. It really depends on what else was said here, but these initial comments tip towards that Sherman antitrust violation, and what else is in here very well could lead into a violation that's provable. And this is all discoverable because you stupidly put it on Facebook. Great job. Great job. Finally, we have a third thing, and you've seen it bandied about on the internet a bunch if you're following this, and that's tortious interference. Let's look at what tortious interference looks like. There's tortious interference with contract, and I'm not going to go there, okay, because tortious interference with contract requires a breach of the contract. So that would be that AP, Antarctic Press, had actually breached their contract with DNC. I don't know that they did that. I've heard the word canceled a lot, and canceling a contract doesn't always rise to breach. If you cancel a contract because of a provision in your contract that allows it to be cancelable, then that's not a breach. That's just following the terms of the contract. So we're going to ignore tortious interference with a contract, and instead we're going to go with tortious interference with a business relationship, which is a lower standard but similar theme. Okay, and based on the facts, it may be tortious interference with contract. Don't know, don't really care, because this is what we're going to talk about. The elements of tortious interference with a business relationship are: 1, the plaintiff had business relations with a third party. It's official. Antarctic Press is publishing Jawbreakers Lost Souls, so we have that without question. 2, the defendant interfered with those business relations. Mark Wade says, I'm going to call Antarctic Press and let them know who they're dealing with. That's an interference with business relationships with a third party. That doesn't mean it rises to the level of an actionable thing yet. 3rd prong, the defendant acted for a wrongful purpose or used dishonest, unfair, or improper means. Defamation is a dishonest, unfair, or improper means, or the wrongful purpose is to keep out competition. Mark Wade is a comic producer. He writes comics that people aren't really buying, and if he's trying to keep out competition through tortious interference or through this interference, that's bad. Defamation or competition can be tortious interference. Okay. And then 4, the defendant's acts injured the relationship. Well, we know we've got 1. We know we've got 2. We know we've got 4. The only question in this case is number 3. The defendant acted for a wrongful purpose or used dishonest, unfair, or improper means, which depends on what Mark Wade said. That's what tortious interference looks like. And by the way, if you guys want to read this whole case, you can go look at RFP LLC versus SCVNGR Incorporated. This is a 2011 case in U.S. District Court for the Southern District of New York. You can look this up. You can find it on like FindLaw or something like that. So you have sole purpose of harming plaintiff, wrongful means. I'm not going to go through these. Go read up on it. Tell me I'm wrong if you want. It doesn't matter. But that's what they have to prove against Mark Wade. Really, it comes down to his words. So finally, the final thing I want to talk to you, because it's getting a lot longer than I wanted it to be, let's look at Mark Wade's statement to No Enemy But Peace. This is a piece called No Enemy But Peace by, let's see, or no, wait, that might be the publication. Let me take a look here. So this is No Enemy But Peace, Richard Meyer, Antarctic Press, and Jawbreakers. It's on bleedingcool.com. And I'm going to go straight to the part. There's a lot in here, kind of a background summary. I don't want to go through the whole thing. Let me just go through Mark Wade's most recent statement here. When I heard that fans and creators were coming down on the AP publisher for doing business with Meyer, I gave him a call. I'd met him before. He seemed like a good guy and something didn't jibe. I was surprised that he'd want to get in bed with someone whose idea of marketing was to ask his fans to put together a list of stores that chose not to carry his book and to then circulate that list along with the full names, first and last, of the store's employees and their phone numbers for ease of targeting and harassment. That's not what happened. That's not even what Wade said happened in the first time, and it's certainly not what DNC said happened. So we've already got a problem here. Okay. And even this might be defamatory on its own because he's saying it to the author of the article. In parentheses, no store owes it to customers to carry every comic. No store carries every comic. Stores pick and choose what they wish to sell based on what they think their customers will support and, to some degree, on their own personal feelings about the subject matter, the publisher's track record, and other factors, including sometimes whether or not they want to put money into the pocket of a creator or creators who publicly refer to women in comics as cum buckets or transgender creator as men in wigs. Well, that's interesting, Mark. And maybe they do that, maybe they don't, but I don't have any info on that. But we do have a lot of info that these same stores stock comics from creators who have said all sorts of awful things because people are people, and sometimes people say awful things, okay? Don't be fooled, he says. By the way, making that list wasn't about selling comics or helping or healing the industry. That could be defamatory because Well, probably not. That's probably an opinion statement. But he can't prove this. This is ridiculous. For that, like Mark Miller does, you'd be supportive and circulate a list of stores that do carry your books, unless you want people to know that they can contact these guys and say, hey, will you please carry my book? Which isn't harassment to ask a retailer to carry a book that you want to buy. This was flat out about punishing and harassing and intimidating the stores who didn't carry his book. That's probably an opinion statement and not a factual statement. The factual statements are him saying this, okay? So this is probably an opinion statement, non-actionable. Then he does a quote, nice store you got here. Be a shame if there was all of a sudden a bunch of 1-star reviews on Yelp and Google. This didn't happen, by the way, from DNC. It may have happened from some of his fans. He's not responsible for the actions of his fans. No one is responsible for the actions of their fans. Get over that legal theory. It doesn't exist. If you want to prove it does, please send it to me. I have yet to see a case that sustains third-party liability in anything like this. Okay, third-party liability is a real weird thing, and it is not in this area of law. Come on. Why else would you make sure a list existed and was circulated that carried the personal information of not the owners but their employees? That is weird, because would it be cool with you if, because I didn't like the way your boss does business, I phoned you directly to complain rather than him? Of course not. Except if you answer the phone at the company. That's literally what happens to customer service people all the time, you idiot. So I called the publisher, who I knew to be a good guy. Listen, I mean, this is a fluff piece here, because I suspected there was more to this than, yes, sign us up to make money for the transphobe. And there was. He's a busy man who has a full-time day job as well as a publishing house, and he's not much for social media, so it never occurred to him to vet the creators. Why would it? That's an honest mistake to make. As a publisher myself, if I see work I like and want to publish, it doesn't automatically occur to me to just, by the way, make sure the creator is a decent human being. But apparently it ought to. Lesson learned. Yes, it does. I can almost guarantee you it does to Mark Waid. Like, otherwise, why would he think like this? I phoned him out of legitimate concern to warn him that there seemed to be a lot of anger directed at him by fans unhappy that he'd so openly embraced someone whose entire reputation was based on harassment and preaching intolerance and bigotry. Look at this guy digging his own grave on Tortious Interference. What a dope. Not warn him like, hey, if you know what's good for you, I'm just saying. Warn him as someone who has respect for him that he may not realize who he'd gotten in bed with. Oh my God. Like, this guy, this is Tortious Interference. It is. Well, it sure looks like it. I shouldn't say it is, because a court can disagree with me, of course. A jury can disagree. But like, these statements are a huge problem, especially if he says his entire reputation is based on harassment and preaching intolerance and bigotry, when his entire reputation is based on a YouTube channel with 1,000 different videos on it that you can go vet yourself and see if it's about harassment and bigotry, or if it's about the fact that he reviews comics and people resonate with his reviews. Maybe that's what it is. I don't know. As it turns out, he was way ahead of me on this. It's not my place to speak for him, but he was appalled. Here you are speaking for him. But he was appalled that the stores he makes his living selling to, were getting harassed. He'd learned an awful lot about his new partner in the previous 24 hours. He and I had a good, productive conversation, listening to one another, disagreeing on some philosophical points, but agreeing on others. Oh man, I would love to hear that call. Again, by his request, I'm not really at liberty to go into detail about the conversation, other than to make it clear that A, he'd pretty much come to his conclusions that he hadn't announced yet about what to do long before I had talked. Yeah, that doesn't look like you guys deciding that, this might be legally actionable. And B, he'll back me up when I report that at no time did I ask him not to publish the book or ask him not to affiliate with his creators. You don't have to. You don't have to ask for this to be tortious interference. You calling and making statements about the creator is enough. But I wonder if you did. I don't have any more right to bully someone into not publishing a comic than they have to bully my publishers. You absolutely are doing it. You're doing it right now. My purpose in calling was to discuss, as we did, the potential fallout and how to navigate it. I offer to, once the dust settles, conduct an interview with him for publication where we can talk about the choices he'd made here and the thinking behind them. They're pretty interesting, particularly when it comes to the difficulty in separating the artist from the art, and I think it'd be terrifically informative. That sort of looks like you offered him something of value in consideration for him to go against publishing this book. It looks like that from your statement. You stupid idiot. What are you thinking publishing statements like this? What are you thinking? Get a lawyer, Wade. You need one to rein in your dumb self. These are the guys. If I was your lawyer, I would slap you when you walked in the door, and then I'd bill you for it. You flipping moron. From my point of view, I think the publisher clearly had no idea what kind of man he was helping to enrich. Just sign the confession. And I'm genuinely impressed that now, knowing what he knows, he's taken a stand even though he's in a no-win situation where he can piss off either his longtime customers and creators or a small but loud lynch mob that embraces doxing and harassment as a marketing strategy. Wow. And look at Diversity in Comics. Immediately says, please don't send any negative messages or energy towards Antarctic Press. They did what they have to do after enduring a vicious wave of bullying from SJW comic book pros that was led by Mark Waid. All right, guys. There you have it. I'm done reading any source material that I have. It doesn't matter. The legal issues in this case, and I apologize that this video is so much longer, but as I got into it, it got me fired up. 1, defamation on the part of Mark Waid. Sure frickin' looks like it. It sure looks like it. I can't say for sure, but it looks like defamation has occurred specifically about the list, saying that he published individual numbers with the intent to harass these people is a lie if those numbers are public numbers of the stores. Saying that he encouraged harassment is a lie if you can't prove that he published harassment or said harassment. All he has to say is, I never encouraged people to harass them, and I can point to here and here where I said, do not call and harass these people. Now, Mark, it's on you to prove that he did. Defamation looks like that's in the mix. Next is violations of the Sherman Antitrust Act. This is kind of the longer shot, in my opinion, but those retailers in that group look like they're involved in anti-competitive practices. It looks like it. I wonder what else is in that group. What other comics they've talked about, what other creators that they have said, look, I'm not going to do it. Are you going to do it? Are you going to do it? Are you going to do it? How many people who get to say yes get to stay in the group? This is a good question. It's a good question. The nature of that group will be critical to the idea that that's a Sherman antitrust violation. The FTC may be looking into it. I know people have contacted the FTC about it. They're who investigate the criminal aspects of it. But technically, Diversity in Comics could bring a civil suit and raise Sherman antitrust issues. Or raise issues based on the theory of unfair competition that is entrenched in law under Sherman antitrust. Okay? That's what that means. And then finally, of course, is tortious interference. And we've got 3 of the elements down. The crucial element is, was this an unfair or deceptive means of interfering with the contract? It looks like it might be. If he used defamatory statements, if he mischaracterized this guy, if his sole purpose was to lock out competition, I don't think the sole purpose is merely to lock out competition or to secure himself as the only creator that would be able to do business dealings with him. That looks weak. But if it looks like the sole purpose was to injure Diversity in Comics, absolutely. That one's no question that he was trying to injure the relationship for Diversity in Comics. He flat out says he's trying to. So that's easy. The second part of that is, does he do it in an unlawful manner? And it kind of looks like it, especially if he characterizes him as someone whose sole marketing strategy is harassment and intimidation and doxing and all that stuff. You can't just say that about people, Mark. So anyway, guys, sorry that this is a 45-minute video. I'm going to end it right away. Thank you for watching. We're going to keep following this. I don't know if a case is coming or not. But it's really interesting to see a bunch of dumb people online talk about the law that they haven't researched with facts that they're not even citing, and about laws that they don't understand. So hopefully you find this informative. And if you do, like, share, follow, all that stuff, and check me out on social media. Argue with me if you think I'm wrong. I'm always happy to be proven wrong too. So if you've got some different information, I'm happy to update my perspective. Thanks for watching. You guys have a good night. Peace.